When you find yourself contemplating divorce, one of the first and most important steps you should take is to meet with an experienced divorce attorney. If you are like many people, your divorce lawyer may be the first lawyer you have ever met or dealt with. This can make your first meeting intimidating, uncomfortable, and unfamiliar, but it doesn't need to be that type of an experience. Your attorney should understand that this is a stressful and uncertain time for you. You should expect them to do everything they can to make you feel at ease and safe as you begin a journey where the two of you work closely together during your divorce process, which can last months. But you can also help yourself by knowing what to expect at your first meeting. You should also be able to know what kind of questions the attorney will ask you, the questions you should ask them, and the information and documentation that you should have ready to make your time as productive as possible. Here's a roadmap for that first meeting that may help you enter your attorney's office with confidence and leave with clarity. In a divorce, the attorney-client relationship is both professional and personal. Not only will you want to have confidence that your lawyer has the background, skills, experience, and approach needed to handle your case, but you also need to feel comfortable with their personality and communication style. You'll want to be at ease discussing difficult subjects with your attorney, and you need to feel that they listen and respond to your concerns. Ask yourself, do they seem in a hurry or distracted? Do they inspire a sense of trust and confidence? Do they speak to you like a client, or do they treat you like a human being? Your lawyer will ask you to provide an overview of your marriage, such as why you are seeking a divorce and any specific concerns or goals you have, such as custody of your children, which assets you might want to keep, minimizing conflict, or maintaining financial support from your spouse. Provide as much detail as possible in response to their questions, and be completely honest, even about things that you may think are unhelpful or embarrassing. Remember, everything you and your attorney say to each other is protected by the attorney-client privilege and is completely confidential. The more information your lawyer has and the fewer surprises that could come up later will help them fully understand your case and determine the best course of action from the outset. Failure to disclose items that could cause issues may lead to advice that does not fit your situation. To the extent that you can, show up to your meeting with as much information and documentation as possible about your personal and marital finances, including such things as income information, banking information, retirement information, property information, particularly real property and big-ticket items, any prenuptial or postnuptial agreements. All of those are important pieces of information to share. Your lawyer will also provide an overview of the divorce process, including key steps such as filing the divorce petition, serving your spouse, and attending court hearings as necessary. They may also explain a potential timeline for your case, how property division works, how the child custody and support decisions are made, and the potential for mediation or settlement discussions. This is your opportunity to ask questions and clarify any aspect of the process you do not understand. A good lawyer will take the time to ensure that you feel informed and empowered. By the end of the meeting, you should understand what the initial retainer will cost, how your attorney bills, and what payment options exist. Often, a prospective client will want to know how much the entire divorce process will cost. There's simply no way to provide a definitive answer as it depends on the specific facts and individuals involved. The more you and your spouse with your respective attorneys are able to work together to dissolve your marriage, the better the impact on your finances. Before concluding the initial meeting, your lawyer will outline how to move forward if you choose to retain them. Sometimes you may be provided a list of items to complete to prepare for the process. If you choose to retain, you will be provided an engagement agreement to sign and asked to pay an upfront retainer or down payment towards services before the attorney may begin working on your case. If all goes as it should, you will emerge from your meeting with a clear idea of how you can proceed. This may give you a sense of optimism and confidence, allowing you to feel empowered with the information you need to move forward. For more information or to answer specific questions about your case, Call Kreis Enderle to schedule a consultation today.